Good evening, students. Good evening, everyone. So we are here for the second day, second session of Law, CA Foundation, to give insights on certain additional topics that are added for our syllabus. So in today's session, I will be covering this unit 7 that has been added to your Contract Act. Good evening, good evening. Please make sure you inform your friends that we are live and make sure that they also join the session at the earliest. Yes, do inform your friends and everyone and make sure everybody joins the session in time and so that we can proceed ahead and discuss today's topic. So in today's topic, two types of contracts are getting discussed. One we call as contract of indemnity. The other one is called as contract of guarantee. So what is contract of indemnity? What is contract of guarantee? Everything will be discussed in today's session. Let us start our discussion for the day. We already have few numbers here. So many more to join. Please make sure you ask your friends also to join. Inform them that we are live and we are going ahead with our discussion for the day. So in today's class, two types of contracts are to be discussed. One is called as contract of indemnity. The other one is called as contract of guarantee. So indemnity, first and foremost thing that I'm going to discuss is about indemnity. So what exactly do we mean by indemnity? So we have slides which explains the word here. Since for the sake of convenience of our discussion, the topics are presented in the form of slides since we are meeting online. If it is like physical classes, we'll use board and interactive classes will be there. So to make things simpler, what we have done is we have put up slides here. And these slides are already available for you in the VOS portal. The same slides I have used so that since it is academic purpose, I am using the same slides so that it will be easier for you to make reference to the slides. So in the VOS portal, the same will be available. So students can take help of the things that are available in VOS portal. Yes. So indemnify, the word indemnify, we are discussing about contract of indemnity first. Contract of indemnity. So under contract of indemnity, first we have to understand what exactly do we mean by indemnity. The word indemnity comes from this word called as indemnify. Indemnify means to make good the loss incurred by another party. We come across this term in the Partnership Act. Section 10 says partner has to indemnify the firm for the loss caused to the firm by his fraudulent conduct. When a partner acts fraudulently, any loss that happens to the partnership firm, partner has to indemnify such loss. This is the concept we learn under Section 10 of Partnership Act. There we come across this word. And in various other circumstances also we come across this particular word. So indemnifying, indemnification, indemnity, all these things are derived from this word called as indemnify, which means to make good the loss. Which means to make good the loss. Making good of loss is called as indemnity. Making good of losses is called as indemnity. So this contract is all about making good of loss. When one party promises to other party that if any loss happens, I will compensate you. Such an act is called as indemnification. Such a contract is called as indemnification. So indemnify. to make good the loss incurred by another person, to compensate the party who has suffered from some loss. Section 124 of the Contract Act defines contract of indemnity. It is a contract by which one party promises to save the other from loss caused to him by the conduct of the promiser himself or by the conduct of any other person. So, how can we put this in the form of an example? Either by the conduct of the promiser. Let us say, see, we have Sneha here. Let us say Sneha wants to get a house constructed. Sneha wants to get a house constructed. So, she appoints an engineer. As a part of their contract, engineer says, I'll construct the house for you. I'll construct a good, beautiful house for you, for which Sneha will agree to pay some consideration. Along with that, engineer also promises that if any harm happens to the house within 5 years of construction, maybe it starts pouring in, or the seepage starts, or something like that happens to the building, the engineer says, if anything of that kind happens, I will compensate the loss. I will give you good quality of house. So if anything happens to the house, I am responsible for that. So what engineering is saying is, engineer is saying that if anything happens based on his construction, if any loss happens to Sneha, he will compensate the loss. So what engineering is doing is, engineer is promising to indemnify. So this contract where engineer promises Sneha, if she suffers any loss, he will compensate. Such a contract is called as contract of indemnity. This is what is called as contract of indemnity. Let me give one more practical example that we see in our day-to-day life, which we can refer to. A practical example we can give. Say sometimes what happens is, there will be an insurance company. There will be an insurance company which says that if any fire accident happens for your factory or for your premise, any fire accident happens. Sorry. Some businesses are prone for fire accidents. Maybe you have a factory where there are huge boilers. Or your business needs fire, or you might be running a hotel, something like that. So now, suppose if the insurance company says, if there is a fire in your premise or any loss happens to you because of the fire accident, I will compensate for the loss. This is called as contract of indemnity. This is one way of indemnity. One more example, if I have to give your health insurance company says, if you fall sick and you are admitted to the hospital, I will bear the bill for you. Whatever expenses you are going to incur, I will compensate. Now, this is what is indemnity. Of course, the wordings here are a little bit different. The wordings in the statement say a contract by one party, where one party promises to save the other party from loss caused to him by the conduct of the promiser himself or by the conduct of any other person. But it need not always be because of some persons. Because of some varied circumstances also the loss may happen. In that case also, if one party promises to compensate the other party, we will consider it as contract of indemnity, where one party promises to compensate other party for the loss occurred or loss which is going to occur in future. That is what is called as contract of indemnity. This is the main principle that you have to keep in mind with respect to contract of indemnity. Yesterday, when I wound up the class, I made a very important point that you should remember about contingent contract. Contingent contracts you have to remember. Now, this is a kind of contingent contract because here the contract is to save from the loss. If the loss occurs, if the loss happens, so happening of loss is uncertain. You falling sick is uncertain. Fire accident happening is uncertain. Ship not arriving at the port is uncertain. But still, there is a contract which is dependent upon that particular uncertain event. That is why it is kind of contingent contract only. So a contract by which one party promises to save the other party from the loss caused to him by the conduct of the promiser himself or by the conduct of any other person. See, one more example we will give. Let us try to understand this. What exactly happens? say sometimes in an employment contract, what happens? There will be an employee. There will be an employee. Now, this employee wants to go for higher studies. Employee is working in a company, let us say Infosys or some company, Reliance or some company, and this employee wants to go abroad for a higher studies, or maybe the employee wants to take up higher studies. Now, normally what companies do is, if the employee wants to take up higher studies, that too in the related field, some field that is related to their business, so the employers normally agree to sponsor that higher education, so that what they think is, if employee gets the higher education and comes to us, the quality of work will increase, and because of that the company will be benefited. So employee tells to the employer that he wants to go for higher studies, so employer agrees to sponsor. Employer says, I will sponsor your higher studies, whatever expense happens, I will sponsor that. But there is one condition. There is one condition. After your completion of education, you should work for me for 5 years. After completion of your education, you should work for me for 5 years, failing which you will have to compensate me for the entire expense that I'm incurring for your higher studies. Whatever expenses I'm incurring towards your education, you have to compensate. Now, when employee promises employer that if he doesn't work for next 5 years, whatever loss the employer is going to suffer for the sponsorship, that will be compensated by employee. I will consider it as contract of indemnity. This is also an example of contract of indemnity. So everywhere one party is promising other party for compensating a loss or to bear an expense which is going to occur in future, which may occur or which may not occur. That is, which is not very certain on the date of entering the contract. This is what basically is called as contract of indemnity. This is what is called as contract of indemnity. Now, going to the analysis of the definition, section 124 covers losses caused by conduct of the promisor himself. The employee example which I gave now, there for the conduct of the promisor, he is agreeing to compensate. If the employee doesn't work for the entity, he is going to compensate. So there the conduct of the promisor, by the conduct of the promisor, the loss may occur, then compensation will come. Sometimes by conduct of any other person. Sometimes conduct may be because of any other person also. So theft. Let us say burglary insurance. We take up burglary insurance. That means if the jewels get stolen, the insurance company will compensate you. There, the conduct is by any other person. You cannot steal, no. If the conduct is by any other person, in that case also, there is proper contract of indemnity. But the thing is, while reading section 124, it gives us a doubt. If promisee himself conducts the things, when I do something, I fall sick. When I do something, there is a loss happening. Will that be compensated? Will that be compensated? Probably there is no proper clarity in section 124. Section 124 is not very clear about this. Further, accident due to accidental situations. So vehicle insurance you purchase, accident happens and vehicle is damaged. Will that be covered under contract of indemnity? Even that is not covered. Act of God. So natural calamities occur and because of that there is a loss suffered. Will that be compensated? Even that is not covered under section 124. You should take a careful observation of section 124. However, when a particular matter is not clear in the law, we always go for reference to the case laws. We always refer to the case laws. So we have a case law, Gajanan Moreshwar versus Moreshwar Madan. We have a case law named Gajanan Moreshwar versus Moreshwar Madan. The decision is taken on the basis of English law. As per English law, indemnity means promise to save another harmless from the loss. Here it covers every loss, whether due to negligence of the promisee or by natural calamity or by accident. So the summary is very simple, sir. Indian Contract Act doesn't speak anything about loss caused by act of promisee himself. ನಾನೇ ಮಾಡಿದ ತಪ್ಪಿಂದ ನನಗೆ ಎಲ್ಲಿಯಾದ್ರೂ ಲಾಸ್ ಆದ್ರೆ ಅಂತ ಲಾಸ್ಗಳು ಸೆಕ್ಷನ್ 124 ಅಲ್ಲಿ ಕವರ್ ಆಗೋದಿಲ್ಲ. ಆಕ್ಸಿಡೆಂಟ್ ಇಂದಾಗಿ ಆದ ಲಾಸ್ಗಳು ಸೆಕ್ಷನ್ 124 ಅಲ್ಲಿ ಕವರ್ ಆಗುದಿಲ್ಲ. ಆಕ್ಟ್ ಆಫ್ ಗಾಡ್, ದಟ್ ಇಸ್ ನ್ಯಾಚುರಲ್ ಕೆಲಾಮಿಟೀಸ್ ಇಂದ ಆಗುವಂತ ಲಾಸಸ್ಗಳು, ಇಫ್ ಎನಿ ಲಾಸಸ್ ಹ್ಯಾಪನ್ಸ್ ಬಿಕಾಸ್ ಆಫ್ ನ್ಯಾಚುರಲ್ ಕೆಲಾಮಿಟೀಸ್, even those things are not covered under section 124. But when the matter came up before the court in the past, same matter when it was brought before the court in the past, what court said is, by relying upon English law, we can say that indemnity, the word meaning of indemnity means promise to save another harmless from the loss. If one person is getting harmed, or if one person is getting loss, saving him from the loss is ultimately called as indemnity. So going by this particular word meaning, the law needs to cover loss caused by negligence of the promisee, or by natural calamities, or by accident also. So this is what is the definition of section 124, definition given under section 124, which we are predominantly relying upon. So 124 should always be read with this particular case law also, which gives us the importance of contract of indemnity, or the gist of contract of indemnity. Now moving on further, contract of indemnity bifurcates two parties to the contract. By contract of indemnity says that there are two parties to contract of indemnity. There are multiple parties, two parties to contract of indemnity. Now, who are the parties? Party who promises to compensate for the loss. One party who suffers the loss, to him, if the other party is saying that he will compensate, the party who is promising to compensate, is called as indemnifier. So insurance company, if it is promising to compensate for any loss that has happened to you, insurance company will be considered as indemnifier. I'll consider the insurance company as indemnifier. On the other hand, person to whom this promise is made, person to whom it is said that if there is any loss, we will compensate, or whose loss is made good, is known as indemnity holder, or is also called as indemnified. It can be either indemnity holder or indemnified. So normally insurance policy, person who buys insurance policy, we call it as policy holder. Similarly, person who is going to get compensated, person whose loss is going to be compensated, is called as indemnity holder. We consider him as indemnity holder, or he also called as indemnified. So you can see an example given on the screen. Mohan contracts to indemnify Sohan against the consequence of any loss due to fire. Now here Mohan is indemnifier, the person who is giving the promise, the promiser in case of contract of indemnity is called as indemnifier, and the party to whom the promise is made is called as indemnity holder. The party to whom the promise is made is called as indemnity holder. I hope the things that we are discussing here are clear to us, my dears. Please make sure you give a response in the chat box so that I can confirm that you are understanding the topics that we are discussing. Yes, please give me a confirmation. Even though there is a timing difference between me and you, there is a slight lag of some seconds. Still, I can wait for your response. Please make sure you are understanding the concept here clearly. That's very nice. That's very nice. So we are getting responses from the students here. We have good number of students, and everybody is responding here. That is nice to see. Let me continue the discussion. How contract of indemnity is entered? How contract of indemnity is entered? See, there are two ways of making contract of indemnity. There are two ways. First one is express. Express contract of indemnity. Express contract of indemnity means when I state it, when I expressly state that I am going to compensate the loss. So where there is a express promise and express acceptance, it is called as express contract of indemnity. Sometimes you infer it from the circumstance. Sometimes you infer it from the circumstance. Let me give you an example. Let us say Anil is there. One fine day, Anil brings a cattle to an auctioneer. Auctioneer is a person. Normally, we see this person in Sale of Goods Act. Sale of Goods Act, we come across this person called as auctioneer. Auctioneer is the person who is going to auction the goods that you give. Seller normally appoints a person called as auctioneer. Auctioneer will sell the goods. Correct now. So now Anil brings a cattle to auctioneer to get it auctioned. Auctioneer auctions it to third party. What auctioneer does is auctioneer auctions it to third party. Now, after the auction gets completed and everything is done, the original owner of the cattle comes. That means Anil is not the original owner. Anil found the cattle somewhere. He brings it and gives it to the auctioneer. And based on his direction, auctioneer believes that it is Anil's cattle and auctioneer sells it. Now, original owner comes and sues auctioneer, saying that you have auctioned my cattle without my permission. You have to compensate me. Now, you see here, auctioneer just did what Anil said, correct? Because of the orders of Anil, auctioneer has auctioned it, believing that Anil was the owner of the cattle. So here what happens is, whatever loss auctioneer will suffer because of this, because of the case filed by original owner, whatever loss auctioneer suffers, auctioneer can recover it from Anil. Even though there is no express contract between Anil and auctioneer, law implies a contract there. Law implies a contract because auctioneer did it at the discretion of the Anil. Auctioneer is just an agent. Anil is the principal. So what court says is, or what law assumes is that there exists a contract of indemnity for whatever loss auctioneer suffers. Anil will be liable. Anil will be made liable. Anil will have to compensate the auctioneer. Anil will have to compensate the auctioneer. This is called as implied contract of indemnity. This is what is called as implied contract of indemnity. When the contract is to be inferred from the conduct of the parties or from the circumstance of the case, we consider it as contract of indemnity. This is also an example of contract of indemnity. Now, one important thing you have to understand, if the compensation is for doing a legal act, it is 100% identified by law. But where compensation is for, where the promise for compensation is for the act which is illegal in the eyes of law, then probably will not consider it as contract of indemnity. So all essential elements of valid contract must also be present in the contract of indemnity. This is one of the important thing which must be kept in mind. All essential elements of a valid contract. So essential elements of valid contract we have discussed in the yesterday's session. Section 10 of the Contract Act tells us what are the essential elements of contract. All such essential elements must be present for a contract of indemnity to be valid one. So let us take this example given here. X asks Y to beat Z and promises to indemnify Y against the consequence. Y beats Z and is fined rupees 1000. Y cannot claim this amount from X because the object of agreement was unlawful. So tomorrow Y cannot go to court and say, sir, I have hit Z because X had said me, now you are imposing fine on me. So please ask X to compensate me. I cannot say this in the court of law because the thing is, the act is unlawful in the eyes of law. So you will not be protected. You will not be protected. Even though there is a contract, the contract is void. Law considers the contract as void. Now, why will the loss arise? Another important thing. Why will the loss arise? Because here ultimately the thing is about compensating the loss. Loss hegagtade. Why will the loss arise? If we ask this particular question, the law says that contract of indemnity must specify that indemnity holder shall be protected from the loss caused due to either action of the promisor himself. Promisor means person who is promising, either for his own act or action of any other person because of any other reasons, or any act, event, or accident which is not in the control of both the parties. Uncontrollable events, because of some uncontrollable events, if the loss happens, in that case also the loss may arise and such a loss will be compensated. Such a loss will be compensated. Now, coming to the last part of this contract of indemnity, one last thing, right of indemnity holder. As against indemnifier, what and all rights will indemnity holder enjoy? What are the rights that indemnity holder enjoys against indemnifier? There are three rights. One, right to recover damages. Two, right to recover costs. 3, right to recover other sums. Now, what do we mean by this? Damages. Damages means loss. Actual monetary loss. All damages which he may be compelled to pay in any suit in respect of any matter to which indemnity implies. So let me give another example for this so that the things will be very clear for us. Let us say there is a wholesaler or there is a manufacturer. There is a manufacturer. Manufacturer appoints a retailer to sell his goods. Retailer sells the goods to customer. Let us say manufacturer enters into contract with retailer that manufacturer enters into contract with retailer that if retailer suffers any loss due to defect in the goods, manufacturer shall compensate retailer. Manufacturer shall compensate retailer. So if this is the contract, now what happens is, let us say retailer sells a goods to customer. Customer finds the goods defective and because of which customer suffers some loss. Customer suffers some loss, injury or loss. So he sues retailer because privity of contract is between retailer and customer. So customer sues retailer. Now in return, whatever retailer is paying as damages to customer, whatever retailer is paying as damages to customer can be recovered from the manufacturer. Retailer can recover it from the manufacturer. So that is nothing but damages. Now, sometimes what happens is instead of damages, matters may be settled outside the court. Compromise. There might be a compromise. See, because reputation is involved when customer files a case against the retailer, what happens is the business will get affected. So they may decide to get the matter settled outside the court. So through compromise, they may get it settled. In that case also, whatever amount is paid by the retailer, that is what is covered in the other sums. Whatever amount retailer pays to the customer as compensation for the compromise, even that can be recovered as other sums, either damages or other sums. Or now when customer sues retailer, retailer has to defend the case. So thereby retailer will incur certain cost, appointing an advocate, court fees and all those things, retailer will incur some cost. Such cost can also be recovered from the manufacturer. Such cost can also be recovered. So these are the 3 important rights that indemnity holder enjoys against indemnifier. He can recover the damages, he can recover the cost of the suit, and he can also recover any other sum as a part of compromise, So this is what is called as contract of indemnity. So with this few things, we conclude the discussion on contract of indemnity. I hope it is very clear to us. Whatever discussions we have concluded now, please make sure that you are clear with this discussion so that I can proceed ahead for the next topic. Shall we proceed? Very nice. Okay. Now let us continue further for the next topic to come up. That is nothing but contract of guarantee. So after completing contract of indemnity, we are going for the next topic, that is contract of guarantee. Now to explain this contract of guarantee, let me take an example and then let me elaborate this particular case. Let me take an example and with the example, I'll try to elaborate this particular thing. Give me a second. Okay. Let me take an example so that I can elaborate this particular case. Let us explain this like this. Let us say there is a company, Kingfisher Airlines. There is a company called Kingfisher Airlines. Let us say this. There is a Kingfisher Airlines company. Now, Kingfisher Airlines wants to borrow some money. Kingfisher Airlines wants to borrow some money. So it goes to this bank called as State Bank of India. It goes to State Bank of India asking a loan of rupees 100 crores. Asking a loan of rupees 100 crores. So it tells SBI, I need a loan of 100 crores. Please give me a loan of 100 crores. Now, what SBI says is, I can give you the loan, but I need someone who can guarantee your repayment. Who can guarantee or who can assure your repayment. So what happens is, this guy comes ahead, comes forward. Sri Vijay Mallya. Sri Vijay Mallya ji, Honorable Sri Vijay Mallya ji comes forward, and Vijay Mallya ji promises SBI. Vijay Mallya promises SBI that if Kingfisher Airlines fails to repay, I will repay the loan. If Kingfisher Airlines fails to repay the loan, I will repay the loan. Now here, whatever contract is entered between Vijay Mallya and State Bank of India is called as contract of guarantee. Vijay Mallya is giving an assurance. Vijay Mallya is giving a guarantee. Vijay Mallya is saying that if Kingfisher Airlines is not going to pay, I will pay for it. So thereby, this particular contract between Vijay Mallya and SBI is considered as contract of guarantee. This is called as contract of guarantee. So what do we call Vijay Mallya in this particular contract? Vijay Mallya will be called as surety. Vijay Mallya will be called as surety. SBI will be called as creditor. SBI will be called as creditor. And Kingfisher Airlines will be called as principal debtor. Kingfisher Airlines will be called as principal debtor. We are identifying the parties in this particular contract. So where surety promises to compensate, or surety promises that in the event of failure by principal debtor, surety will pay, surety will perform. This is what is called as contract of guarantee. Normally, in case of loans, we see this type of guarantee. It's not always limited to only loan transactions. There are other transactions also where we can see this contract of guarantee. But in loan transactions, we see this frequently. In our layman's term, in our normal language, we call this as Jamin Hakku. Jamin. So this is what is called as Jamin. So here, what exactly is happening is one party is promising the other party that where a third party fails to do something, I will compensate or I will pay for it. This is what is called as contract of guarantee. Sir, this is not contract of indemnity. Contract of indemnity, one party promising to indemnify loss to another party. Loss may be caused by any person. Compensation, there it is more of a compensatory nature. Here it is not of a compensation, but here it is about the performance part. Here it is about the performance part. Let me give another example. See, this is normally called as financial guarantee. Financial guarantee is normally given in case of loans, where one party says that if one party principal debtor it doesn't pay the loan, I will repay it. This is what is called as contract of guarantee, financial guarantee. One example for financial guarantee. Let me give you one more example. Let us say there is a car manufacturing company called as Jaguar Land Rover Limited. There is a company called Jaguar Land Rover Limited. Say Jaguar Land Rover Limited enters into contract with British government. British government wants to purchase 100 cars. It wants someone to manufacture and give 100 units of cars. So Jaguar Land Rover Limited enters into contract or promises British government that we will manufacture. Now British government says we can give you the contract, but we need someone who can assure the performance. That means in case of your failure, there should be someone who can perform this contract. In this case, Tata Motors Limited. Tata Motors Limited gives a guarantee to British government. Tata Motors Limited gives a guarantee to British government saying that if Jaguar Land Rover fails to manufacture 100 cars, we will manufacture the car and supply it to you. We will manufacture same standard car and we will give it to you. Now here, the contract between Tata Motors Limited and British government, where Tata Motors Limited is promising British government for the performance of Jaguar Land Rover Limited, is called as contract of guarantee. Even this is considered as contract of guarantee. Here, the guarantee is for a performance. That is why I call it as performance guarantee. See, this happens in our layman's language. We normally use these terms in our layman day-to-day transactions. You tell he does the best things. He does the best thing. So let's say you want a cloth to be stitched. You will ask your friend who is the good tailor in the city, who is the best tailor in the city. Your friend recommends someone and he says, "Adake nan guarantee mare. I'll give a guarantee for his performance." Now, this is what is called as contract of guarantee. Of course, there it is not formally done, but when it is formally done, it is called as contract of guarantee, where one party assures the other party that he will guarantee the performance or he will guarantee for the financial part. That is what is called as contract of guarantee. Even in this case, Tata Motors will be considered as surety. British government will be considered as creditor. Jaguar Land Rover will be considered as principal debtor. This is what is called as contract of guarantee. This is what is called as contract of guarantee. I hope it is clear. The basic part is clear here. Yes. Now, I'll further elaborate this. Let us go one step ahead here. Let us see how many types of contracts are there in this particular contract of guarantee. Say, you are a wholesaler, or I'll name some parties so that things will be easier for us. Let us say Anil. Say Deepak is there. And say Vaishak is. Anil, Deepak and Vaishak, three parties are there. Deepak has to supply goods to Anil on credit. Credit supply of goods. For which Vaishak has given a guarantee. The guarantee by Vaishak is that if Anil fails to pay the bills, Vaishak will pay the bill. If Anil fails to pay the bill, Vaishak will pay the bill. So the contract between Vaishak and Deepak will be considered as contract of guarantee. Contract between Deepak and Vaishak will be considered as contract of guarantee. Now observe the fact. For a contract of guarantee, there should be a primary contract. Without a primary contract, contract of guarantee is not valid. Primary contract is between Anil and Deepak. Contract of supply of goods and payment of price for that. So Deepak agrees to supply goods to Anil, Anil agrees to pay for it. Now, if Anil fails, only then the question of Vaishak paying him will come into picture. So this is first contract, which we consider it as principal contract or primary contract. Primary contract will be between principal debtor and creditor. Primary contract. In case of contract of guarantee, you should always observe this. There should be a primary contract only on which there can be a contract of guarantee. Primary contract will always be between principal debtor and creditor. Second one is this contract of guarantee, secondary to the primary contract, that is called as contract of guarantee. Now, contract of guarantee is between surety and creditor. Surety and creditor. Now, see, there is one more implied contract, which is between principal debtor and surety. That if surety makes the payment to the creditor, principal debtor will have to compensate the surety for his loss. Principal debtor will have to compensate the surety for his loss, which I'll call as contract of indemnity. This is what is called as contract of indemnity. It is actually implied contract of indemnity. This is an implied one. Law assumes that if surety pays the amount, obviously surety is paying out of his pocket. It is just that because of surety, this transaction is done. Even though surety is making the payment, it's actually the primary liability of Anil, primary liability of the principal debtor. That is why law says, as between principal debtor and surety, there is a contract of indemnity. That means if surety makes the payment, then it becomes the duty of principal debtor to compensate the surety, So this contract of indemnity between principal debtor and surety. So thereby it is a triple agreement, three agreements in one particular transaction. This is what is called as contract of guarantee. This is what forms the prelims of contract of guarantee. We have many more things to discuss under this, but this is what is the primary part that we need to understand. I hope it is very clear to us, everybody. Please make sure that it is clear to us. Yes, my dears. Please give me a confirmation whether the things that we are discussing here is clear to us. Now let us discuss the points as per our material. Points from the material. Let me close this. So here, contract of guarantee is discussed under section 126. A contract of guarantee is a contract to perform the promise or to discharge the liability. Either it is for performing the promise or discharging the liability. Performing the promise is what we call as performance guarantee. Discharging the liability is what we call as financial guarantee, paying off the liability. So both cases we have explained. One in case of Tata Motors, the other one in case of Kingfisher Airlines. Of a third party in case of his default. It's a contract to perform the promise or discharge the liability of a third party in case of his default. So here, there is a contract you see. B promises to discharge A's liability in case of A's default. Give a car to my friend. If he does not pay, I will pay. So B is called as surety. B is giving a guarantee here. Contract between B and C is contract of guarantee. C is actually the creditor and principal debtor is A. Principal debtor is A. So this is the brief analysis of contract of guarantee. Now, parties, the person who gives the guarantee is called as surety. The person who gives the guarantee is called as surety. The person in respect of whose default the guarantee is given is called as principal debtor. The person to whom the guarantee is given is called as creditor. The person to whom the guarantee is given is called as creditor. So these are the parties to contract of guarantee. So we have a few more examples. You can refer to it on the screen. We'll discuss it. Few more examples are on the screen. You can see them. Sandeep requests Chaman to lend rupees 10,000 to Prashant. If you can see there, they have used the word yes, see. S for surety. C for creditor. P for principal debtor. Now Sandeep is requesting Chaman. Chaman is going to lend money. So if you draw this in the type of in the image, you can see like this. Creditor is Chaman. Chaman is going to lend to Prashant rupees 10,000, for which Sandeep is giving a guarantee. Sandeep is giving a guarantee. And guarantees that Prashant will repay the amount within agreed time. And if Prashant does not pay, he, that is Sandeep, will himself pay to Chaman. There is a contract of guarantee. Here Chaman is the creditor, Prashant is the principal debtor, Sandeep is the surety. Similarly, example 5, if you see. S asks C to sell table fan to P and agrees that if P fails to pay, he will pay. In case of P's failure, S will recover the money from, C will recover the money from S. So it should be C. C will recover the money from S. This is one more case of contract of guarantee. Now we discussed types of contracts. That is what is analyzed in the next slide. There are 3 contracts between principal debtor, creditor, and surety. Contract number 1 is between contract number 1. I'll consider this as contract number 1 instead of this. Contract number 1 I'll consider as this one. This will be considered as contract number 3. Contract number 1 is between creditor and principal debtor. Contract number 2 is between surety and creditor. And contract number 3 is between principal debtor and surety. This is an implied contract. Contract number 3 is implied contract. Though it is not expressly stated, it will be considered as a contract. It will be considered as a contract. Essentials for a valid contract of guarantee. What are the essential elements for a valid contract of guarantee? First thing is there should be a principal debt. Without a principal debt, there cannot be a contract of guarantee. So there should be a contract between principal debtor and creditor, for which there is a guarantee. If this is not there, this is also not. The purpose of guarantee should be to secure payment of a debt or performance. If there is no debt, there cannot be no valid guarantee. The debt or liability must be legally enforceable and not time barred. Again, another important observation. So suppose if creditor has given a loan for which surety has given a guarantee, and that particular loan becomes time barred, that means not enforceable. Now you cannot enforce it against surety also. You cannot hold surety also liable. So A gives guarantee to B for payment of a time barred debt due from C. This is not a valid contract. This is not to be considered as a valid contract. Consideration. Now you see, one important factor is that between surety and creditor, there is no consideration. Between surety and creditor, there is no consideration. Normally, for a contract, there should be consideration, and consideration should be quid pro quo, one-to-one relationship. But this is considered as an exception for contract of guarantee. In case of contract of guarantee, creditor will give the consideration to principal debtor, and the contract is between principal debtor and creditor. So whatever benefit principal debtor is going to derive, that itself will be considered as enough consideration for contract of guarantee. So in our examples, in every example that we give, see here, the loan is coming from SBI to Kingfisher Airlines. As between SBI and Vijay Mallya, there is no consideration coming in. For Vijay Mallya's promise, there is no consideration coming in. Still, this itself will be considered as valid consideration for Vijay Mallya's promise. The loan given to principal debtor itself, the contract between creditor and principal debtor itself is considered as valid consideration. That itself will be considered as valid consideration. Similarly, there is no consideration coming from British government to Tata Motors, but whatever British government is going to pay to Jaguar Land Rover, this itself is considered as a valid consideration for Tata Motors Limited. This itself is considered as a valid consideration. So that is one point to be kept in mind. Consideration. Contract of guarantee should be supported by some consideration, but need not be direct consideration between surety and creditor. Any benefit received by the debtor is adequate consideration to bind the surety. Any consideration received by debtor is an adequate consideration to bind the surety. This thing you have to keep in mind. B requests C to sell and deliver him 100 kgs of sugar on credit. S guarantees the payment. Here C's promise to deliver goods to P is a sufficient consideration for S promise. Therefore, the guarantee is valid. The guarantee will be considered as valid guarantee. This is with respect to third important essential element of valid contract of guarantee. So this consideration point, important one, please make sure that you have understood it clearly. Consideration point is important. Please make sure you have understood it clearly. Please give me a confirmation if you have understood it clearly. Very nice. This is with respect to third important point. Now, fourth important point says that while you obtain a guarantee from a person, there should not be any misrepresentation or concealment of fact. You should not lie to the person who is giving a guarantee. Because a person is giving a guarantee for another person, any misrepresentation done to him any concealment of fact done to him. That means if you are not disclosing something to him, that will tend the contract of guarantee void. Contract of guarantee void. Now see this example. S guarantees to C payment for 100 quintals of dry wheat to be supplied by him to P. C is the creditor who is going to supply 100 quintals of wheat to P at market price. Now P and C have secretly agreed that P should pay rupees 10 per quintal extra to C, which is not in the knowledge of S. You have not informed this to S. You have simply said, I'll be selling it at market price. But between principal debtor and creditor, there is a secret agreement where it says the principal debtor will be liable to pay 10 rupees extra. And this is not been brought to the notice of the creditor. Sorry, surety. This has not been brought to the notice of the surety. Now there is a concealment of fact from surety. Hence, surety is not liable. S is not liable as a surety. S will not be considered as liable for the acts. Because misrepresentation. Whenever a surety or guarantee is obtained by misrepresenting the facts, whenever a guarantee is obtained by concealing the facts, the surety cannot be held liable. The surety cannot be held liable. Next, contract of guarantee may be written, contract of guarantee may be oral. There is no clear rules which says that it should be written only. It can be either written or it can be oral. And the last one is one more important point to be kept in mind. Suppose, say, let us take our Vijay Mallya's example. We have Kingfisher Airlines, three parties, Kingfisher Airlines, SBI, and Vijay Mallya. Now, Vijay Mallya, while giving a guarantee, puts a condition. Vijay Mallya says, I will give guarantee only if Nirav Modi joins me as co-surety. Vijay Mallya has put up a condition saying that I will be surety, I will give guarantee only if Nirav Modi also joins me as co-surety. That means I need a companion to give guarantee. Entire 100 crore rupees I alone cannot bear. So I need someone to be a co-surety, and I am putting a condition. So here surety is putting a condition that the surety will be valid only if one more co-surety is added. Now, if creditor gives any loan to Kingfisher Airlines, even before the co-surety is added, even before the co-surety is added, if SBI gives a loan to Kingfisher Airlines without following the condition, then this contract of guarantee will be invalid. This contract of guarantee will be invalid. Where a person gives a guarantee upon a condition that creditor shall not act upon it until another person has joined in as co-surety, the guarantee is not valid if that other person does not join. The guarantee is not valid. Till the other person joins, the guarantee will not be considered as valid contract of guarantee. So this is one more point to be kept in mind with respect to contract of guarantee. So coming to the essential elements of valid contract of guarantee, first one said that there should be a principal debt, and in that particular debt, that should exist the liability, enforceable liability should be there. There should be consideration, and consideration need not be given to surety. It is sufficient if the consideration goes to principal debtor. There should not be any misrepresentation or concealment. Contract of guarantee may be oral or written, and wherever contract of guarantee is based on a condition that creditor shall not act upon unless the co-surety is added. If creditor acts upon even before the co-surety is added, the contract of guarantee shall not be valid. It shall not be valid. These are the things to be kept in mind with respect to characteristics or essentials of valid contract of guarantee. Please make sure you have understood these particular concepts clearly. Whether it is clear to us, everybody. Before I continue to the next topic, I will give you a small break of 2 minutes just to get refresh, and then we'll again bounce back and we'll continue our discussion. Only a 2 minutes break will be available. So this is not to log out or anything, just stay back. It is just to keep you in track of what we are discussing. Just take a brief break of 2 minutes and come back. I'll just switch off the video. That's it. Let us restart our discussion here. So continuing our discussion, uh, so continuing our discussion here, types of guarantee. Two types of guarantees are there. In case of contract of guarantee, there are two types of guarantees. One is called as specific guarantee. The other one is called as continuing guarantee. One is called as specific guarantee. The other one is called as continuing guarantee. Now, what do we mean by specific guarantee and what do we mean by continuing guarantee? See, if a guarantee is given for a one particular transaction, if a guarantee is given for a particular transaction, I'll consider it as specific guarantee for one specific debt or for one specific performance. If a contract of guarantee is given, such a contract of guarantee is called as specific guarantee. Guarantee which extends to a single debt or specific transaction. Your friend is purchasing a car. You tell to the car owner or you tell to the car seller that you sell him the car on credit. He will pay you the money. If he doesn't pay, I will pay. Here the contract is very specific for one particular car, one particular transaction. This contract is called as specific guarantee. This contract of guarantee is called as contract of specific guarantee. Surety's liability comes to an end when the guarantee debt is duly discharged. Once he pays the amount of the car to the car seller, the surety's liability comes to an end. No more liability, no more relationship. There, the particular thing ends. This is called as specific guarantee. Coming to the continuing guarantee part, where the guarantee is given for a series of transactions, where a party gives a guarantee for a series of transactions. Now, what exactly do we mean by series of transactions? Let us say there is a manufacturer of a goods. Your friend wants to purchase the goods and sell it to the customers. Now you are the person who are giving the guarantee. You tell to the manufacturer, you supply any goods to him. I will give the guarantee for that. First bill, 50,000, the goods are supplied. Second bill, 30,000, goods are supplied. Third bill, 80,000, goods are supplied. Fourth bill, 90,000, goods are supplied. Fifth bill, again 50,000, goods are supplied. Like this, 5 different transactions are done. After you have given the guarantee, 5 different transactions are done. Now your guarantee is extended for each of these transactions. Because you said whatever goods he supplies, you are going to give the guarantee. This is what is called as continuing guarantee, where guarantee continues for a series of transactions. I'll consider it as continuing guarantee. So here what happens is, till you revoke the guarantee, you will be continued to be liable in the transaction till you revoke. Let us say first transaction, second transaction, third transaction, fourth transaction, fifth transaction. After fifth transaction, you say, anymore I am not liable. I'm stopping my guarantee. Anymore, don't supply him any goods. Even if you supply, I am not liable. Now what happens is, from fifth transaction onwards, that means up to fifth transactions, you continue to be liable till it is settled. From fifth transaction, from sixth transaction onwards, whatever happens, you will not be liable. Your guarantee comes to an end. Your guarantee comes to an end. Liability is still pending. Guarantee is coming to an end. Liability, when it will come to an end? Till once the bills of all these 5 transactions are settled, your liability will also come to an end. This is what is called as continuing guarantee. This is called as continuing guarantee. One specific transaction, a guarantee is given, specific guarantee. If the guarantee extends for a series of transactions, it is called as continuing guarantee. It is called as continuing guarantee. Continuing guarantee is intended to cover a number of transactions over a period of time, but a guarantee for one specific transaction comes to an end as soon as the liability under that transaction ends. I guarantee for the payment to the amount of 5 sacks of flour to be delivered to be payable in 1 month. If you supply 5 sacks of flour, I will be liable. That's what he is saying to be. When C is going to supply sacks of flour to B, and if B fails to pay, A is saying that he will pay. Now suppose if C supplies more than 5 sacks, 10 sacks he supplies. Now for balance 5 sacks, A is not liable. A is only liable for 5 sacks. Sacks means bags. Because his guarantee is specific for 5 bags only. Once the 5 bags are supplied, for future transaction, whatever happens after those 5 bags, for that A will not be liable. That is specific guarantee. That is called as specific guarantee. Continuing guarantee example, you see, Avadhesh guarantees Mukesh, a canteen owner, to supply lunch to his employees for time to time up to the value of 10,000. See, every time you supply tiffin to my employees, I am guarantee. If they don't pay, I'll pay you. You give food to my employees. Here, till the value of 10,000, whatever lunch is supplied for any time, the surety will be liable for that. This is called as continuing guarantee, because every time the food is supplied, the surety will be liable for it. Every time the food is supplied, the surety will be liable. This is called as continuing guarantee, because here the guarantee extends for a series of transactions. The guarantee extends for a series of transactions. This is what is called as continuing guarantee. Yes. Now coming to the next part, difference between contract of indemnity and contract of guarantee. We discussed both the contracts now. So let us establish a difference between both of them. In case of contract of indemnity, there are two parties. In case of contract of guarantee, there are three parties. Contract of indemnity is between indemnifier and indemnity holder, whereas contract of guarantee is of course between surety and surety and creditor, but the parties involved are surety, principal debtor, and creditor. So that is the difference. Contracts. In case of contract of indemnity, there is only one contract. One party promises to indemnify the other party from loss. Whereas in case of contract of guarantee, there are three contracts. One between principal debtor and creditor. Two between surety and creditor. Three between principal debtor and surety. Primary liability. In case of contract of indemnity, liability of indemnifier, party who has promised to compensate the loss. His liability is primary. Whereas in case of contract of guarantee, liability of surety is secondary, liability of principal debtor is primary. Only if principal debtor fails, then surety's liability arises. Commencement of liability arises only on happening of contingency, arises only on default by principal debtor, already discussed. Suit. Indemnifier cannot sue third party in his own name unless there is an assignment in indemnifier's favor. Otherwise, he must bring the suit in the name of indemnified. So tomorrow, if the indemnifier is suffering any loss, or if there is any breach or anything of kind, he cannot sue third party directly. He can only sue indemnified. That is the thing. Whereas if the principal debtor fails to pay and surety discharges his debt, surety can proceed against the principal debtor in his own right. So he can sue principal debtor in his own name. Indemnifier need not act at the request of indemnity holder. Surety acts at the request of principal debtor. Purpose reimbursement of loss for security of the creditor. See, of course, there are few points which institute has given, which I don't watch personally. It is for the sake of points, they have included certain points which are not very clear as per the syllabus. So, as such, if you remember the meanings, that is more than sufficient. If you remember the meaning between them, it is more than sufficient. You can differentiate in your own words, no problem. Moving on further, nature and extent of surety's liability. What is the nature of surety's liability? See, section 128 clearly states that liability of the surety is coextensive with that of principal debtor. Coextensive means it exists together with the liability of the principal debtor. That is, surety is liable for what? Principal debtor is liable. However, the contract of guarantee may provide otherwise. Coextensive. When I say coextensive, that means for whatever liability principal debtor is liable, only for those liabilities surety will be liable. Or we can also say for whatever liability principal debtor is liable, for all such liabilities surety will also be liable. X gives guarantee to Y for payment of debt of rupees 10,000 due from Z. On due date, Z could not make the payment. An unknown person made a payment of 2,000 to Y on behalf of Z. Now, actually, when unknown person makes a payment, we know that acceptance of performance from third party. When a performance is accepted from third party, the promisee cannot demand the performance from the promisor up to that extent. So in this case, when 2,000 is accepted on behalf of X, sorry, on behalf of Z from a third party, Z cannot be held liable to the extent of 10,000. Z can only be held liable up to the extent of 8,000. When Z can be held liable only to the extent of 8,000, even X can be held only to the extent of 8,000. Coextensive. Whatever liability principal debtor is liable for, only for those liabilities, surety will also be liable. So that is called as coextensive. The liability of the surety arises only on default by principal debtor. So when principal debtor is to perform, when principal debtor is to pay, if he doesn't pay, only then surety's liability will arise. Suppose If the creditor cannot hold principal debtor liable for the defect in the document, their documentation was not proper, because of which surety creditor is not in a position to hold principal debtor liable. He cannot even hold surety liable. Where a debtor cannot be held liable on account of any defect in the document, liability of the surety also ceases. Liability of the surety also comes to an end. However, where principal debtor can be held liable by the creditor, creditor may hold principal debtor liable or creditor may hold surety liable. So there is no compulsion saying that it is compulsory for the creditor to hold principal debtor liable. Creditor may also sue surety instead of suing principal debtor. Anything is fine. A creditor may choose to proceed against a surety first, unless there is an agreement to the contrary. This is one thing to be kept in mind. So, if principal debtor cannot be held liable because of the default in the document, then surety also cannot be held liable. But where principal debtor can be held liable, surety has an option, sorry, creditor has an option either to sue principal debtor or to sue surety. He can do anything. However, in the contract, if it is written that it should be principal debtor who should be sued first and only then surety should be sued, then we'll go with the contract. Otherwise, creditor has an option either to sue principal debtor or to sue creditor, also or to sue surety or to sue surety. This is what is the thing you have to keep in mind under section 128. Is it clear? Please give me a confirmation if it is clear to you. Yes. Now let us see modes of discharge of surety. When will surety's liability come to an end? Or when will the contract of guarantee come to an end? Which we called as modes of discharge of surety. Let us discuss this one by one. There are three different set of discussions covered here. One by revocation, two by conduct of creditor, three on invalidation of contract of guarantee. In these three circumstances, the surety is said to be discharged. The surety is said to be discharged. First one is by revocation. First one is by revocation. Revocation means ending the contract of guarantee, revoking, taking back the contract of guarantee that you have given. You have given the guarantee to a person, you are taking it back. That is called as revocation. Now, first one is by notice. Revocation by notice. If the guarantee given is a specific guarantee, such guarantee cannot be revoked by notice once the liability is incurred. You are giving a guarantee for a particular loan to be given. Once the loan is given, after the loan is given to the principal debtor, you cannot revoke it back. But where contract is continuing guarantee, then it can be revoked. But in case of continuing guarantee, the guarantee can be revoked, but only with respect to future transactions. Only with respect to future transactions and not for past transactions which are already done. Transactions which are already done, for those reasons, you cannot revoke the contract. For future transactions, the contract can be revoked. For future transactions, the contract can be revoked. So, where the revocation is happening as to continuing guarantee, till the date of revocation, whatever transaction has happened, for that, the surety will continue to be liable. For those transactions which are happening after the revocation, surety will not continue to be liable. Surety will not be liable. So we have already given the example there. For you had given a guarantee to a manufacturer for supplying the goods. Now, when you say after 5 transactions, when you say that anymore I'm not liable, you are revoking it by notice. For those transactions, for 1, 2, 3, 4, 5 transactions, whatever is there, you will continue to be liable. For 6th transaction onward, you will not be liable. Yes, guarantee C for transaction to be done between C and P for next month. After 5 days, yes, informs C and P, he is not the surety anymore. The continuing guarantee is revoked for future transaction, but S is still surety for transactions done during those 5 days. For those 5 days, if any transactions are done, for that, the person will be liable. This is with respect to discharge by revocation, that too by notice. Discharge by notice. Okay. Moving on further. Discharge of surety by revocation, taking back. That is in case of death. See, even in case of death, one thing you have to keep in mind. If the guarantee is a specific guarantee, for one transaction you have given the guarantee, irrespective of death, irrespective of the notice, nothing can revoke such guarantee because the transaction is already done. That means if you die, your estates will be liable for the particular transaction. However, in case of continuing guarantee, from the date of death of the surety, the continuing guarantee stands revoked. From the date of death of surety, from the date of death of surety, the continuing guarantee stands revoked. That means from the date of death, for future transactions, surety's estates will not be liable. However, for the transaction done till the date of death, sorry, surety's estate continue to be liable. For the transactions done till the date of death, surety's estates continue to be liable. So, on death of surety, a continuing guarantee is automatically revoked in respect of future transactions. However, surety's estate remains liable for the past transactions which have already taken place before the death of surety, S guarantees C for the transaction to be done between C and P for the next month. The surety guarantees creditor for the transaction to be done between creditor and principal debtor for next month. After 5 days, surety dies. Now, guarantee is revoked for future transactions, but yes, estate is still liable for transactions done during the previous 5 days. Till the date of death, whatever is done, for that, he will continue to be liable. Last among this is discharge of surety by revocation, that is by novation. Now, what is novation? Novation is nothing but substituting an old contract with a new contract. Let us take the example first and then let us see the provision. Surety guarantee C for payment of supply of wheat to be done by creditor to principal debtor for next month. After 5 days, the contract is changed. Now, surety guarantees creditor for payment of supply of rice to be done by creditor to principal debtor for the rest of the next month. Here, the guarantee is revoked for supply of wheat, but surety is still liable for supply of wheat done during previous 5 days. Novation, in case of novation, what is happening is an old contract is getting substituted by new contract. When an old contract is substituted by new contract, guarantee given for an old contract comes to an end. For new contract, you may be guarantor or you may not be a surety. That depends on the contract. However, the surety given, the guarantee given for the old contract stands revoked. These are the 3 ways where surety will be discharged by revocation. Now, discharge in the sense as to future transaction is discharged. For transaction already done, he continues to be liable till the debt is settled. Till the debt is settled. These are by revocation. Next one. Discharge of surety by conduct of creditor. Sometimes creditor's behavior discharges the surety. What are those circumstances? We should understand. Variance in the terms of the contract. Now, see, originally something was agreed between three parties. I have given a guarantee for something. The same thing is agreed between principal, debtor, and creditor. Now, principal, debtor, and creditor are changing the terms of the contract without my consent. I am the surety. Without my consent, they are changing the terms of the contract. Automatically, I will stand discharged where I am not taken where they are not taking my consent. From that date, the variation is taking place. I'll stand discontinued to be a guarantee. I'll stand discharged to be a surety. Let me give an example. Say, Deepak wants a staff for his office. Deepak wants a staff. He goes to Srinidhi. Srinidhi suggests Vaishak as the right candidate. Srinidhi says Vaishak is the best person to be appointed in your office. Now, going by the words of Srinidhi, Deepak agrees to appoint Vaishak in his office on the guarantee of Srinidhi. Srinidhi says, if any loss happens to you, I am liable. I will pay it too. Because of him, because of his bad performance, if you suffer any loss or if anything happens, I'll give the guarantee for it. Now, after this, what happens is, let us say the salary agreed for this. The salary agreed for this is say 15,000 rupees. Deepak has agreed for a salary of 15,000 rupees to be paid to Vaishak, for which Srinidhi has given a guarantee. Srinidhi has given a guarantee for the performance of Vaishak. After 5 months, Srinidhi and Vaishak alter their contract, whereby Srinidhi now promises to pay a salary of 20,000 rupees to Vaishak. Without the consent of, Deepak agrees to pay a salary of 20,000 rupees to Vaishak without the consent of Srinidhi. Surety's consent is not obtained. They have varied the terms of the contract. Now, what happens is, from that particular day when the salary is increased, surety stands discharged as to future transactions. For none of the future transactions, surety will be liable. This is when the terms of the original contract is varied without the consent of the surety. If subsequent to the formation of a contract of guarantee, any variation is made in the terms and conditions of the contract of guarantee, and such variation is made without the consent of surety, and surety shall be discharged for such transactions as take place after such variation. After the variation, whatever transaction happens for those variations, surety shall stand discharged. Surety will not be held liable. So till 15,000, when the salary was up to 15,000 rupees, whatever wrong things, if Vaishak has done, you can hold surety liable for it. But from the date you increased the salary without the consent of the surety, you cannot hold him liable as to any of those transactions. You cannot hold him liable as to any of those transactions. This is variance in the terms of the contract. Next one, release or discharge of principal debtor. When will the surety is discharged? When will surety get discharged? Now, when the creditor and principal debtor enters into a fresh contract, when the principal debtor and creditor enters into a fresh contract, which has the effect of releasing the principal debtor. which has the effect of releasing the principal debtor. Releasing the principal debtor means you are entering into a contract whereby you are saying, I will not hold you liable at all. You are making a contract with the principal debtor saying that you will not hold him liable at all. Having the effect of releasing the principal debtor. You cannot hold him liable. Anta situation bandre, then surety shall stand discharged. Or when the creditor does any act or omission, the legal consequence of which is discharge of principal debtor. So let us see the example given there. Principal debtor contracts with the creditor for a fixed price to build a house for the creditor within a stipulated time. Creditor supplying the bricks. Surety guarantees piece performance of the contract. Here, creditor fails to supply the bricks to principal debtor. Surety is discharged from surety because you cannot hold principal debtor itself liable. Thereby, surety can also be cannot be held liable. So, if the creditor is doing any activity, the legal consequence of which is discharge of the principal debtor. In this case, creditor should have supplied the bricks based using which principal debtor would have constructed the house. When creditor fails to supply the bricks, automatically what happens is principal debtor stands discharged from the contract. Reciprocal promise, where performance of one party is dependent on performance of another party. In that case, the party who has to perform first, if he fails to do that, the other party stands discharged. Same thing happens here also. Here, when the creditor fails to perform his part, that is when creditor fails to supply the bricks, principal debtor is discharged. Automatically, what happens is surety will also stand discharged from the contract. Surety will stand discharged from the contract. The surety is discharged if the creditor makes composition with. Now, composition normally happens when there is a loan to be paid. Composition means maybe you are reducing the amount of debt. You were liable to pay 5 lakh rupees. Principal debtor was liable to pay to the creditor 5 lakh rupees. Now creditor is saying it is sufficient if you pay me 3.5 lakh rupees. That is called as composition. If creditor is making any composition with principal debtor without the consent of surety, or if the creditor is giving time to principal debtor for repaying or performing the debt. Earlier, the loan was actually for 1 year. Now he is giving 15 months time. That is 3 months extra without the consent of surety. Then also surety stands discharged. Or where principal debtor and creditor make an agreement whereby creditor promises principal debtor not to sue him. They maintain agreement saying that I will not sue you at all. In this case also, surety stands discharged. So composition, giving time, or agreeing not to sue. In all these cases, surety shall stand discharged when it is done without the consent of the surety. Creditor sells an AC to principal debtor on which payment to be made after 2 months. Surety guarantees for the same. On due date, principal debtor requests creditor to extend the time for payment by 15 days. Creditor allows without informing surety, surety shall stand discharged. So if there is a composition, or if there is a time extra given, or if there is an agreement not to sue, in all these cases, surety shall stand discharged. Surety shall stand discharged. However, there are 2 observations to be understood. Suppose if the creditor is entering into an agreement with third party to give time to principal debtor, this will not discharge the surety. This will not discharge the surety. Say, for example, there is principal debtor and there is creditor. Principal debtor has promised to pay. After 6 months, for which surety has given a guarantee. For the promise to pay after 6 months, Surety has given a guarantee. Now, creditor has assigned this right to receive the money to a third party. Assignment. Assignment normally happens when I transfer my benefit to you. Whatever I have to receive, if I transfer it to you, it is called as assignment. Now, creditor has assigned it to third party, let us see. And creditor is entering into an agreement with third party saying that if principal doesn't pay even after 6 months, don't sue him for next 2 months. Creditor is entering into an agreement with third party. Creditor is entering into an agreement with third party saying that even if the principal debtor doesn't pay you, don't sue him for another 2 months. 6 months ಆದ್ಮೇಲೂ ಪೇಮೆಂಟ್ ಆಗಲಿಲ್ಲ, ಮತ್ತೆರಡು ಟೈಮ್ ಬಂತು ಅವನಿಗೆ ಟೈಮ್ ಕೊಡು. Creditor is actually entering into contract with third party for giving time to principal debtor, not with principal debtor. If creditor gives time to principal debtor directly, then surety is discharged. But when creditor is entering into contract with third party to give time to principal debtor, then surety is not discharged. Surety continues to be liable. Surety continues to be liable. So this thing has to be clearly understood. So where there is a contract to give time to surety principal debtor, and such a contract is made by creditor with a third party, surety is not discharged. Where creditor gives time to, or creditor agrees to give time to principal debtor, and the agreement is between principal debtor and creditor, then surety is discharged. The next one is creditor's forbearance to sue does not discharge the surety. Forbearance to sue means when the principal debtor has to perform. If he does not perform and creditor does not sue him, that doesn't mean creditor cannot sue surety. Mere forbearance. Forbearance means not suing. Merely because creditor does not sue principal debtor, that will not discharge the surety. C sells AC to P on which payment to be made after 2 months. S guarantees for the same as surety. On due date, P did not make the payment. C did not sue P for a year. S will not be discharged. Just because principal debtor is not sued. If there is an agreement between principal debtor and creditor, that's a different story. Where there is no agreement, but just like that, surety is not suing. Sorry, creditor is not suing principal debtor. Then I cannot say that surety will be discharged. Surety will not be discharged in such a case. Surety will not be discharged in such a case. Is it clear? Please give me a confirmation there. Now, next one. Discharge of surety by conduct of creditor, the last point. Impairing surety's eventual remedy. See, if surety has a remedy, and that remedy is impaired by the conduct of the creditor, that remedy, whatever is available for surety, is impaired by the creditor. Let me give a simple example. Say, creditor has given a loan to principal debtor, and surety has given a guarantee. Surety has given a guarantee. Along with the guarantee, creditor has also taken some jewelry as security. Creditor has also taken some jewelry from the principal debtor as security. Suppose due to the carelessness of creditor, if these jewels are lost. Due to the carelessness of creditor, if these jewels are lost. What happens is, surety's remedy is lost. It amounts to loss of remedy of the surety. Why I will call it as loss of remedy of surety? Because had principal debtor defaulted, surety would have been asked to pay the creditor. If surety would have paid the creditor, these jewels would go to surety. These jewels would go to surety, which he could use for recovering the amount from the principal debtor. Now, because of the negligence of creditor, this particular remedy which was available for surety is lost. Thereby, to that extent, surety will be discharged. Suppose if the jewelry covers the entire loan amount, for the entire loan amount, surety is discharged. If it is for the part amount, to that extent, surety stands discharged. So, what the provision says is, it is the duty of the creditor not to do anything which is inconsistent with the right of surety. If creditor fails to protect the surety's right, the surety is discharged. Surety is discharged. One more example. Suppose, let us say Basavraj. Basavraj is a chartered accountant. He wants a staff for his office. He wants a staff for his office. So Pranjal recommends Abhilash for the purpose of appointing him as staff. And Pranjal gives guarantee for Abhilash's performance. But Pranjal puts a condition. Pranjal says, you ask him to do anything, you ask him to work on anything, but never give him cash. Never ever give him cash. Because this guy is not good in handling cash. There's a possibility that he may run away with the cash. So don't give him the cash. Now, what Pranjal is doing is, Pranjal is safeguarding her interest, saying that don't give the cash. For any other activity, I'm liable. But with cash, don't give him cash. That instruction has been given. Now, suppose if Basavaraj, violating the terms imposed by Pranjal, gives cash to Abhilash, the eventual remedy of Pranjal is lost. Thereby, Pranjal stands discharged from the day when Basavaraj hands over cash to Abhilash. Because the eventual remedy that was available was not to hand over the cash. Once the cash is handed over, what happens is automatically the party stands discharged, the surety stands discharged from the contract. So these are the situations where surety stands discharged by the conduct of the creditor. By the conduct of the creditor. Because of the behavior of the creditor, surety stands discharged. Last one is, sometimes the contract of guarantee will be invalid because of some reasons. In that case, the contract of guarantee, the surety will be discharged. Discharge of surety on invalidation of contract of guarantee. We have already discussed this. First one being guarantee obtained by misrepresentation. You are obtaining the guarantee from a person by giving him wrong informations. So see there, C sells, creditor sells a air condition to principal debtor on misrepresenting that it is made of copper, while actually it is made of aluminium. Actually, it is made of aluminium. Surety guarantees for the same as surety without the knowledge of the fact that it is made of aluminium. Surety has given the guarantee believing that it is made of copper. But what creditor has done is, creditor has misrepresented the fact. In this case, once the fact is revealed, the surety shall stand discharged because there is a misrepresentation. A misrepresentation or fraud doesn't matter in both the cases. Something which is intentionally done, unintentionally done. In both the cases, surety shall stand discharged. Any guarantee which has been obtained by means of misrepresentation made by a creditor concerning material part of the transaction. An important part of the transaction is misrepresented, automatically it will discharge the surety from the contract. Next is guarantee obtained by concealing the material fact. Earlier was wrong representation. This one is concealment of fact. That means without saying something that is very important, you have obtained the guarantee. Something that was compulsory to be said, you did not say it. Say, for example, you are running a hotel. Now you have a cashier in your hotel. For a long period of time, he has been embezzling the cash. Every day he steals some cash from your counter, and you get to know this on a particular day. So now you are preparing to remove him from the job. Now the cashier says, please don't remove him. I will not repeat this. I'll not repeat this anymore. Please don't remove. So you say, bring me someone who can give guarantee for your performance. Bring me someone who can give the guarantee. So the cashier goes to his friend, brings the friend to the hotel owner, that is to you. And the friend says, sir, please keep him as cashier. I will give guarantee for his performance. Now see, if the friend is made aware about the previous behavior of the principal debtor, that is cashier, then the contract of guarantee is valid. But where you are not telling him that earlier he has done such and such embezzlement and asking him to get the contract of guarantee, such a contract of guarantee will be void. Surety cannot be held liable because you are concealing a material information. Any guarantee which creditor has obtained by means of keeping silence as to material circumstance. Law says that creditor has the duty to tell it. Where creditor is not saying it, surety shall stand discharged. Is it clear to us? Section 43, 143 is what we are discussing. And the last one is guarantee on the contract that creditor shall not act on until post-surety joins. Section 144. Where one person gives a guarantee, Vijay Mallya's example I had said, where Vijay Mallya is giving a guarantee saying that until the Nirav Modi joins, his guarantee will not be valid. Now, if the creditor acts upon without admitting or without joining such other co-surety, then the particular surety shall stand discharged. Where a person gives a guarantee upon a contract that creditor shall not act upon until the other person has joined in as co-surety, the guarantee is not valid if that other person does not join. If that other person does not join. S1 guarantees creditor for payment to be done by P to the creditor on the condition that S1 will be liable only if S2 joins him as co-surety. S2 does not give his consent. S1 will also not be liable. Even if the creditor has given the guarantee, given the loan, then also S1 will not be liable because the condition clearly states that only if S2 joins, S1 will be liable. Otherwise, S1 cannot be held liable at all. S1 cannot be held liable at all. So these are the circumstances in which the guarantee stands removed. The guarantee discharges. The surety's liability shall be discharged. So let us summarize it once again. Discharge, or what we say as mode of discharge of surety. First set is based on revocation. Second set is based on conduct of the creditors. And third one is invalidation of contract of guarantee. In case of revocation, there are three things: by notice, by death of surety, and by novation. In case of conduct of creditors, when creditor varies the terms of the contract without the consent of the surety, surety stands discharged as to future transaction. When principal debtor is released or discharged, the surety also stands discharged. When creditor enters into composition or gives time or agrees not to sue the creditor, principal debtor, then also surety shall stand discharged. Or if surety's remedy is impaired by the creditor, then also surety shall stand discharged. Last, sorry, last one is on invalidation of contract of guarantee, where contract is obtained by misrepresentation, where contract is obtained by concealment of fact, where guarantee was obtained upon a condition that creditor shall not act upon until the co-surety joins. If co-surety does not join, in all these cases, the surety shall stand discharged and surety cannot be held liable at all. Surety cannot be held liable at all. These are the basic things to be kept in mind with respect to contract of guarantee. As the last part of the discussion for this chapter, what we have is rights of the surety. What are the rights? If you are a surety in a particular contract, what are the rights that you enjoy? Which I'll be taking up in the next session to come. So make sure you have understood whatever we have discussed in today's session. I have kept it to very limited area. So very few things are discussed. Please make sure that you have clearly understood all these concepts before we proceed to the next class. So come prepared for the tomorrow's session. We'll have a discussion on rights available for the surety. And further, we can also start our discussions on contract of bailment or contract of pledge. Contract of bailment and contract of pledge. That is the target that we are going to keep for the tomorrow's session. So I hope things are clearly understandable for you. These are important areas and there can be practical questions asked in the examinations from these areas. So make sure you also cover up the institute material questions and also the content of institute material. As far as possible, we have made all the efforts to keep the discussion very limited to what institute says in its material. Unnecessary things are not included. Very limited things based on ICA material are discussed in the class. So please make sure that you read it from the ICA material and come prepared for the next class. Thank you. Take care. Have a day. Sorry. Thank you. Take care. Have a good day. We'll meet back tomorrow. Again, tomorrow's session, probably tomorrow's session is being scheduled between 8:30 to 1 o'clock. So we'll meet back tomorrow morning sharp at 8:30. Yes. So till then, thank you. Take care. Have a good day. Bye bye. Bye bye.